to keep your name off the property. So we have two choices. We can set up a land trust and call it, if I'm going to transfer title from my name into this trust, I can call it the Coons Trust. I take the property, I transfer in there. Clint Coons is trustee of the Coons Trust. Any anonymity? Do people know that I still own the property? Could you figure out that I'm still the owner of this property? What gave it away, Rod? Really? Yeah, good, you're quick. So the fact that my name's still on there, there's no anonymity there. But how about if we did this? We created the 375 Any Street Trust. Come up with any name you want for these things. They don't have to be filed anywhere. Private document. 375 Any Street Trust with Rod as the trustee. Put it into there. Do you see Clint through this cup? You don't. All you see is the cup. You don't know who's behind this cup. You see Rod as a trustee. I still show up in the chain of title. Okay, I'm still in the chain of title, but it shows Clint, from Clint's name to the 375 Street Trust with Rod as the trustee. I'm in the chain of title, but I'm not listed as the current owner. There's nothing to attach me to this property. So what would we then do with this trust? Well, in the past, people have taken this trust and used it as a mechanism to transfer title to property without alerting the banks to the fact there's been a title transfer. For instance, I'm in a distressed situation. I'm about to lose my house to the bank. Rod comes along, or let's say Rod comes along and he says, I'll tell you what, Clint, here's what I'm going to do for you. I am going to bring your loan current. I'm going to pay the property taxes, bring them up to date. You're going to give me the house and I'm going to give you $2,000, and then he's going to go about and try to sell it on his own or put a tenant into it. This is called a subject to deal. He's purchasing the property subject to the existing financing, which is under my name. Okay? So Rod now wants to buy this property from me subject to the existing financing. The only problem is that if I sell Rod the property outright and the bank finds out about the fact that there's been a property transfer, what would they do? Call the due on sale clause, right? The due on sale clause, which allows the bank to accelerate the note and make Clint pay it off, which I would say then, Rod, you got to pay off the note. Rod doesn't want to have to go out there and get financing to pay off this note because he's buying other properties and he doesn't want this one to show up on his credit. So Rod says, Clint, this is what I want you to do. I want you to create a trust and deed the property from your name into this trust. Now I want you to take the trust and put it or transfer it to me. Now the fact that Rod has transferred the trust now from my name to his name, does that show up on any recorder's database that the bank can find out about? No, it's private. Nobody knows that I no longer own the property. All the bank would see is that Clint had set up a trust and he transferred his property from his name into the name of this trust. And typically what I would do when the people engaged in this, Clint would be set up as the trustee and the initial beneficiary. And then I sell it to Rod for $2,000 subject to all these terms and conditions that he's going to pay off or reinstate the loan, bring it current, pay all the property taxes, pay all future property taxes. So the bank doesn't know. They're getting a check every month from Rod. They don't care. Now the note's being paid. They're not going to say anything because the money's coming in. When you transfer that title to Rod, Rod's concern is you go bankrupt. And then they go and they take this property right back. Rod says, wait a minute, I reinstated the loan for Clint. I paid his property taxes. I have a secured interest in that. And the trustee says, no, you don't. It's in my name. So he's at risk for you going bankrupt. Now, you're at risk that if you transfer the title to him, he doesn't pay it, right? What do you care? You hadn't paid it to begin with. He reinstated it. He actually saved you some money. Now, if he goes default on it, you're in the same situation you were in prior to him doing this. This particular strategy was utilized quite heavily in 2005, 2006, and 2007 by real estate investors who were going after people that were in a distressed situation, taking title to their homes, reinstating their loans, and then going out there and finding another seller for them and skimming off the profits. Now, is it legal? Well, some states have taken the view, attorney generals, that it's frowned upon. They look upon this as a negative transaction. You know, it really depends. I have a client here in Washington who engaged in this transaction with somebody. See, I would always counsel people not to do this, but I understand you will. This person, what they did is this. They reinstated the loan to the tune of $50,000. They dropped about $45,000 into repairs into this house, and they paid the people $10,000 to move out. And they set it up through a land trust. They did this in September of 2006. Now, they then anticipated selling the property by October of 2006. November. Couldn't sell it. Had a difficult time selling it. January of 2007, still haven't sold it. February 2007, still haven't sold it. Now, March, they get an offer on the property, a serious offer. They make the mistake of contacting the original owner of the property that they bought it from, subject to, because my clients now have been paying the mortgage on time, they've been keeping the taxes current, and they completely rehabbed the property. They tell them, hey, listen, I know this property still shows up on your credit. They didn't have to do this because the people sold it with full knowledge that this was the deal, subject to deal, that it was going to show up on their credit, that they were saving their credit for them by paying it off. They said, but we've got a buyer. This thing should close by the end of April. It's got a 60-day close on that. So what did the original sellers do? They no longer own the property now. The trust is owned by my client. So they went out and hired an attorney. And the attorney sent my clients a threatening letter, and they said, you have committed fraud against my clients, and you pay us $20,000 or we're going to file lis pendens on your property. Now, if they filed a lis pendens on the property, it would cloud title. If they cloud the title, it would destroy the sale. My clients have been holding on this property for 5 months. They want out of it, and they're breaking even on it as it stands right now by getting this buyer to come in. Blackmail. So I call, they're panicking, I'm on vacation, they want me to call the attorney up right away to find out what the heck's going on. I call the attorney up, and this attorney's in Tacoma, and this is exactly how the conversation went. He starts telling me how his clients have been damaged as a result of my clients purchasing this property in this transaction. And I said, what do you mean they've been damaged? Oh yeah, my clients have been unable to obtain a loan at a 6% interest rate because this property still shows on their credit. Therefore, they're only being offered loans at about 7%. I know I can tell by the look on your face here what you're thinking. I said, wait a minute. My clients saved your client's credit. They wouldn't even be getting a loan right now. That's none of my concern. It's none of your client's concern either, the transaction. We're talking about what happened today and how they've been damaged. And he's going on and on and on about this. And finally I said, listen, I'm on vacation. I don't have time to listen to this. I don't know, nor do I want to. What's really at issue here? What's going on? He goes, what, you don't know? I said, no, I really don't. I'm at a loss as to why you're even contacting me. My client's paid your client $10,000 to move out of the property and reinstate a loan for $50K. Like, it seems like you guys have received ample consideration. He goes, it's simple. Your clients have jobs, mine don't. Those are the words out of that attorney's mouth. My response was, get better clients in, and I hung up on him. Yeah, my clients, when I told them this, they were shocked that I spoke to the other attorney that way. I said, the guy's an SOB. All he's trying to do is shake you down. He should have never told me that his clients, that they don't have a job, because that tells me what? He's not having money to pay his attorney. Attorneys don't work for free. Right? They'll give out you one courtesy phone call, one courtesy letter, but they're not going to continue on down this road where they're not going to get paid. I said, just trash it. You'll never be contacted again by this guy. And they never were. And they sold the property and they got out of it. But You see what could happen though? Engaging in those types of transactions. Let's say they did have money and they did want to thwart it, and they have. This situation's come up. We have a few clients who've done this before, and I've told them, give the property back. Well, I spent $10,000. Blah, blah, blah. I go, you want to spend $30,000 litigating? I go, give the property back, because you knew going into the situation that it was a risky transaction because of the way it's structured.